Hey, this is Alex Zouzelas, author of the book Courtroom Confidential. Today's question is, how can a lawyer keep a client with serious medical problems at a federal prison even after he's been given a date to report to prison? Just a reminder, I'm not giving legal advice, just discussing how I addressed the situation on a case I worked on under the supervision of the attorney of record. The case was in federal court in California, but the strategy is applicable in all federal courts. So, first, let's take a look at the facts. The lawyer's client, Mr. A guy in his 60s, had a smorgasbord of medical problems. He suffered from polycythemia, a type of blood cancer that causes bone marrow to make too many red blood cells, thereby thickening the blood and slowing its flow, which may cause serious problems such as blood clots. That's pretty serious. He also suffered from heart disease, including a problem with a coronary artery, which was called the widowmaker. He had unstable angina, hypertension, hypercholesterolemia, a disorder in which bad cholesterol collects in the arteries, putting a person at a higher risk of heart attack and stroke. He had a completely blocked stent, narrowing of his other 5 stents, and a screwed up coronary bypass graft. But wait, that's not all. He also suffered from type 2 diabetes, which had damaged his nerves and blood vessels, high blood pressure, major depression, not the type trauma dumpers have, but the real thing, obesity, something called ischemic cardiomyopathy with decreased ventricular ejection, which placed him in a high-risk category for sudden cardiac death. He had an inguinal hernia that needed to be surgically repaired. I had that done about a year ago. That was a lot of fun. He also had major neck and back problems. His vision was screwed up in one eye and he was totally blind in the other. He had ulcers and other problems with his stomach, and he was starting to experience dementia. His primary treating doctor said that Mr. A's health was so bad that jail really wasn't an option for this guy. And yet, that's what he got. He got 9 months in jail. It was my job to figure out a way to keep him out. My solution was to draft a motion to delay sentencing. That's the first thing I did. You'll see later in the video how to do something else, but we haven't gotten there yet. I argued that the Ninth Circuit Court of Appeals held in 2022 that a district court isn't powerless to provide a semblance of compassionate relief in the normal exercise of its broad discretion. The case I cited was United States versus Fowler, 30 Fed 4th 823 at 827. It's out of the Ninth Circuit, and like I said, 2022. If the circumstances warrant, a district court could delay the imposition of sentence or extend the time to surrender to the BOP. I argue that given Mr. A's serious health issues, the court should delay his reporting to prison and review his health status every 6 or 12 months to make sure he hadn't experienced a miraculous recovery. I also thought of asking the court to ban him from traveling to Lourdes, but I decided that might be a little too much. The sentencing judge agreed, not with the Lourdes thing because I didn't make that argument, but with the other argument, and granted the motion. There was one problem, though, I didn't anticipate. After a couple of years, Mr. A said he didn't want to keep going back to court every year. Instead, he wanted to snatch defeat from the jaws of victory and go to prison and apply for compassionate release, even though the Bureau of Prisons isn't known for jumping right on those applications. So, Mr. Attorney of Record asked me to figure out something, which I did. I argued Mr. A could be granted compassionate release from prison without actually being in prison. How did I do that? Well, I took a look at the statutes and case law. So, starting with, to be eligible for compassionate release, a defendant has to demonstrate that these are the magic buzzwords. Extraordinary and compelling reasons warrant a reduction in the amount of prison time, and that the reduction is consistent with applicable policy statements issued by the U.S. Sentencing Commission. That's found at 18 U.S.C. section 3582, sub C, sub 1, sub A. Although the statute doesn't define extraordinary and compelling circumstances, the U.S. Sentencing Commission has identified 4 categories of situation that may qualify. 1, serious medical conditions. 2, advanced age. 3, family circumstances. And 4, a catch-all other reasons. That's found at United States Sentencing Guidelines 1B1.13 Application Note 1A. In Note 1 to the policy statement, the Commission further identifies 2 extraordinary and compelling reasons that may justify compassionate release for a medical condition. The defendant is suffering from a terminal illness, which is a serious and advanced illness with an end-of-life trajectory. What's important to understand about that is that a specific prognosis of life expectancy, that is a statement that a probability of death is going to occur within a specified period of time, isn't required. You just have to have medical records and statement from a doctor saying that the person's medical problems are such that his illness has an end-of-life trajectory, such as a person who has terminal cancer, for instance. 2, the defendant is suffering from a serious physical or medical condition, suffering from a serious functional or cognitive impairment, or is experiencing deteriorating physical or mental health because of the aging process that substantially diminishes the ability of the defendant to provide self-care within the environment of a correctional facility and from which he or she isn't expected to recover. That's United States Sentencing Guideline, Application Notes, Section 1B1.13, Sub 1, Sub A. Finally, the note recognizes the possibility that BOP could identify other grounds that amount to extraordinary and compelling reasons. Sounds like really discretionary with BOP. That's found at U.S. Sentencing Guidelines, Section 1B1.13, comment to Note 1, Sub D. Also, I'm citing United States versus Perez, case number 08CR3827-01-JAH at page 4. That's out of the Southern District of California, April 27th, 2021. So let's talk about Perez. In Perez, the 68-year-old defendant suffered from numerous medical conditions, the most serious of which was end-stage renal disease. It's a kidney problem he's going to die from. The BOP characterized the defendant's illness as a deteriorating medical condition, true, and based on the defendant's medical history, suggested he may have a steeper than average end-of-life trajectory. You think? The government didn't oppose the request for compassionate release. It admitted that extraordinary and compelling reasons existed independent of the threat of COVID-19, something I'm going to be talking about later in the video, because end-stage renal disease is a terminal illness that meets the definition under Section 1B1.13, comment to Note 1, subsection A, subsection 1. The court found that the defendant's age and underlying medical conditions qualified as extraordinary and compelling reasons to reduce his sentence, consistent with the guidelines policy statement. In my motion, I argued that because of Mr. A's age and his smorgasbord of serious medical conditions, he was similarly situated to the defendant in Perez. But then I had to address the question of whether Mr. A would pose a threat to the public safety if he was released on compassionate release. Also, that he wouldn't pose a risk of flight. So you got to show that also. You got to show the guy's all screwed up medically, but you also got to show that if he's released, he's not going to be a threat to the community. So I looked at Perez again. Perez said that even where extraordinary and compelling reasons exist, a district court must consider whether the defendant is a danger to the safety of any other person or to the community as provided in 18 U.S.C. section 3142 sub G. I just said that before, but I repeated myself. I won't do that again. I promise. To make this assessment, the court has to look at the factors set out in section 3142 sub G, including the nature and circumstances of the offense charged, the history and characteristics of the person, including character, physical and mental condition, family ties, employment, financial resources, past conduct, criminal history, and drug and alcohol abuse, and the nature and seriousness of the danger to any person or the community that release would impose. However, even where a defendant has been convicted of a serious crime and has a substantial criminal record spanning much of his adult life, the court in Perez held that the defendant was not a danger to the community because of his messed up physical condition and BOP's classification of him as a low security risk. So, like the defendant in Perez, the BOP classified Mr. A as a low security risk. Additionally, the nonviolent nature of Mr. A's crime was a factor, I argued, that militated for finding he didn't pose a threat to the community under 18 U.S.C. 3142 sub G. I would also cite the case United States versus Joling, because I cited that case. 466, Fed Sup 3rd, 1141 at 1147. A case is out of the Eastern District of Oregon, April 17th, 2020. But I still haven't addressed exactly how I argued that the court could modify Mr. A's sentence to home confinement or community control without Mr. A's actually being in prison. Well, here it is. Title 18, USC, Section 3582, Sub C, Sub 1, Sub A, provides that a court may reduce a term of imprisonment after it has been imposed if the director of the Bureau of Prisons files a motion, like that's going to happen, or if the director doesn't file the motion within 30 days of being asked to, the defendant can file the motion. Cite United States versus Hambrock, 520, Fed Sup 3rd, 827 at 829. That's out of the Eastern District of Virginia in 2021, and it quotes 18 U.S.C. Section 3582, Sub C, Sub 1, Sub A. Alternatively, the government can waive the 30-day waiting period. It's like you'll be waiting forever for the government to waive the 30-day waiting period. But if the government does, the court can immediately consider and rule on a defendant's motion to modify his sentence based on the circumstances set forth in 18 U.S.C. 3582 Sub C, Sub 1, Sub A. In other words, by granting them compassionate release. But even if the government won't waive the 30-day requirement, a defendant can still move a district court to consider her or his Section 3582 motion without the defendant being in prison. The Court of Appeals in Hambrock noted that nothing in the plain language of the statute requires the defendant to be in custody presently or to have served any portion of his sentence. In other words, per Hambrock, a defense attorney can submit a request to the warden of the facility that the BOP has designated the defendant to report to before the actual reporting date. If the defendant of that facility doesn't bring a motion for compassionate release and 30 days has passed since the warden was asked to do so, the defendant may directly move the district court to modify his sentence, which is exactly what was done by the defendant and approved by the Court of Appeals in Hambrook. The government argued in Hambrook, and this was rejected, that the court couldn't entertain the defendant's motion for compassionate release because the defendant's condition couldn't be evaluated by the BOP since the defendant wasn't in custody. Yeah, like we're just going to ignore this pile of medical documents to say this guy's completely screwed up and he's got an end-of-life trajectory. Okay, but like I said, the Court of Appeals rejected the argument, saying that the statute doesn't require that. In Mr. A's case, I argued that the foregoing authorities established that the court could consider modifying his sentence without his being in prison. If the government was willing to waive the 30-day requirement, I argued, the court could directly consider and rule on Mr. A's request to modify the terms of the incarcerative portion of his sentence by allowing him to serve it on home confinement without his first reporting to prison. Alternatively, in the event that the government was unwilling to do that, and as of the date I drafted that, hadn't heard back from the government, the court could instead delay the date for Mr. A to report to prison for a sufficient period of time to allow his lawyer to file an application for compassionate release with the warden. Then, in the event the warden didn't move for compassionate release within 30 days, the district court could directly consider and rule on a motion to modify Mr. A's sentence by allowing him to serve the prison sentence on home confinement. Last, as I discussed earlier in the video, the court could simply delay Mr. A's reporting date every 6 or 12 months to see if Mr. A's medical condition improved to the point where he could serve his time in prison. And that was never going to happen with this guy's medical problems. So now let's talk about the role of COVID, because COVID still plays a role. Yes, I know everyone wants to forget about COVID, and that's fine, except the law shows that a lawyer representing a client with serious medical conditions in federal court is obligated to address the potential effect COVID can have on a client with serious medical problems. You don't have to trust me on this. A perfunctory search on the internet will tell you that COVID's here to stay and that it poses the greatest threat of death to older persons with chronic underlying medical conditions. People like Mr. A, in other words. So how did I address COVID in the motion? Well, I looked at a case, United States versus Lonich. I'll give you the citation in a second. I argued that at least one court has found that the defendant's age and underlying health conditions constitute an extraordinary and compelling reason to grant release, even though the defendant was vaccinated and had previously contracted COVID-19. That case was United States versus Lonich, number 14 CR 00139, S as in Sierra, I as in India, at pages 4 to 5. It's out of the Northern District of California, April 28, 2021. And it cited United States versus Sweet, not to be confused with United States versus Bitter, which is case number 07, which is found at 07-20369, 2021, Westlaw 1430836, at page 2, out of the Eastern District of Michigan, April 15th, 2021. In that case, the court granted compassionate release to a 73-year-old guy with chronic kidney disease and a smoking history, despite his being vaccinated and previously contracting COVID-19. The court found that the threat of severe illness or death from COVID-19, while diminished, is nevertheless real. As the court noted in Lonich, the expert testimony of an infectious disease specialist and UCLA assistant clinical professor asserted that reinfection of people who have recovered from COVID-19 is possible and more likely in an environment where re-exposure, even with a high viral inoculation rate, is likely. Prisons and jails are such environments. The court in Lonich further observed that the defendant's age and medical conditions placed him at higher risk of complications if infected with the virus, and left open the possibility of reinfection should his health or prison conditions deteriorate. And it's inevitable that his physical conditions were going to deteriorate. The court stated, scientific studies have increased our understanding of COVID-19 risk factors. People who are 65 to 74 years old are 1,100 times more likely to die from infection. That's incredible. The court concluded that the defendant's age in conjunction with the pandemic's rampant spread throughout the prison system constituted an extraordinary and compelling reason warranting his release to home confinement. I think it's important to keep in mind that although COVID isn't the proliferate scourge it once was, it's still around. And because of the close quarters that inmates live in, there's a higher incidence of imprisonment. When I was in prison at FPC Pensacola, I remember a flu virus that ran rampant through the place. I mean, it was really bad. Guys were literally falling out left and right. There were ambulances constantly lined up in front of the dormitories. In one case, I had to catch a guy who'd passed out and was falling face down towards the concrete floor. I called for one of the lieutenants to help, and she did. And I got to tell you, the COs and the lieutenants of Pensacola were great. I'm not getting paid to say that, obviously. Unlike the medical department, they made sure you got to the hospital if you needed to. I heard that on at least one occasion, one of the guards loaded a grievously ill inmate into his personal car, not the inmate's car, the CO's car, and raced him to the hospital. The medical department, they could have cared less. So the point is, COVID is a much greater threat in prison than out of it. Going back to Lonich, the court in Lonich found that modifying the defendant's sentence to home confinement did not offend the need to protect the public from further crimes of the defendant, and that modifying the defendant's sentence to supervised release with a condition of home confinement aligned with the need to provide the defendant with the most effective medical care. Finally, the court in Lonich concluded that in light of the defendant's lack of a prior criminal record, his having kept all court appearances, and his having complied with all the conditions of pretrial release, he wasn't a flight risk or a danger to the community. I use that in my motion. I reasoned that although Mr. A hadn't served any time, he'd been under the supervision of the court since he was originally arrested. That was years. And during that time, he'd meticulously followed and complied with all conditions of his pretrial release. Moreover, he had the unwavering support of his family to help him readjust to a law-abiding life. I contended that his crime was an aberration in an otherwise law-abiding life, which it was. I mean, the guy didn't have any priors. I also argued that even under the stricter standard of compassionate release, Mr. A qualified for home confinement based on his terrible medical problems, case law, statutory law, and BOP policy. I also pointed out the critical fact that the short duration of his sentence rendered his ability to secure compassionate release nugatory if he was in prison. In other words, by the time he went through the administrative process for securing compassionate release, his sentence would be over or he'd be dead, resulting in the absurd situation of Mr. A's serving his sentence in prison when, due to the fact that he qualified for compassionate release, he really shouldn't. So then I took an interesting look at sentencing in Zone B of the sentencing table under the guidelines. Now, Mr. A wasn't sentenced under the guidelines, but I found this argument interesting, so I made it. He got a downward various sentence from the guidelines. The sentence was 9 months prison. And he would have gotten that if he would have fallen within Zone B of the guidelines sentencing table had he been sentenced under the guidelines. And he very well may have. Well, if he got 9 months, he would have fallen in Zone B. This observation, while it wasn't binding on the district court, it nevertheless created a very interesting scenario. Under Zone B, which he would have fallen under given a 9-month sentence if he was sentenced under the guidelines, Mr. A could have, and given his numerous debilitating and life-threatening medical problems, probably would have been allowed to serve all but 1 month of his sentence on a term of supervised release with community confinement and home detention, substituting for the other 8 months of prison time. Indeed, if the applicable guideline range is in Zone B of the sentencing table, a term of imprisonment could be satisfied under Section 5C 1.1 sub C sub 2 by sentencing a defendant to imprisonment that includes a term of supervised release acting as a substitute for 8 months of prison time. The only problematic aspect of such a sentence for Mr. A was the requirement that he serve 1 month in imprisonment, which would kind of be bad for his health. Hence, Mr. A's suggestion that he instead be allowed to serve the entirety of his 9-month sentence on home confinement. So the point of all this is that sentencing in federal court is not an inflexible, caustic, soulless process. Rather, the system is full of myriad choices which accomplish the goal of tailoring the punishment. There's nothing fun about punishment. Tailoring the punishment to fit the unique circumstances of gravely ill defendants. The reality for Mr. A is his medical conditions, especially his coronary problems, his polycythemia, and his cognitive decline will never improve. They're only going to get worse. So while the court could further delay his reporting to the BOP, the delay would likely be indefinite, but by no means guaranteed, because if another judge inherited the case, that one might not be so charitable. The more rational option was to allow him to serve his sentence on home confinement based on the arguments I just described. Well, those are my thoughts on this. I think it's a very interesting subject. Comment on the video. They always generate very interesting discussions. Subscribe to my channel, and if you're a lawyer, consider hiring me to research issues and draft pleadings under your supervision. My contact information is in the description to this video. Thanks for watching, and I'll see you next time.